We have got the JCC panel here today, and we are going to answer every question you've ever had regarding workers' compensation and getting orders entered. Judge Johnsen is going to give his thesis on how to get all of your fees approved. Pay careful attention. And if you don't get the right answer, talk to him afterwards. He'd be happy to share his notes on that front.
Why don't you give out my cell phone number?
I'll do that at the end. We're going to put a PowerPoint so everyone will have that. We've got a wonderful group of JCCs. I really appreciate you all taking the time, starting all the way at the far end, the Queen of the South, the Honorable Sylvia Medina-Shore out of Miami. Next to her, Queen of the North, the Honorable Jacquelyn Newman out of Tallahassee. And then the Squires over here too, close to me. The Honorable Gregory Johnsen out of West Palm Beach. And the Honorable Brian Anthony out of Tampa. Thank you.
We're Squires, we got promoted.
Let's get started here. We're going to talk very quickly with some more introductory topics, and then we'll get into some of the heart of our litigation practice. Starting really with managing a docket. That's part of the judicial role that a lot of people don't really consider, although when you are in the midst of prosecuting a petition for benefits within 210 days, you probably do feel that crunch at times, and we certainly feel it regularly. And so we did want to talk a little bit about how we manage a docket, and that includes even how we set our hearings, evidentiary hearings, final hearings. I know I still hear from lawyers that there is disparity across the state, so I wanted to round up some answers on this. Judge Anthony, evidentiary final, are you doing Zoom, are you doing live, are you doing hybrid? I know Judge Johnsen, I believe, is the only one who still does telephone, Zoom, live, evidentiary final, what factors do you consider? What is the protocol in permitting people to appear via Zoom when you set live? How do you run through that?
Well, normally for final hearings, mine are all scheduled live. Excuse me, and you can go ahead and file a motion for exceptional circumstances on why you're going to appear by Zoom. You're not going to get a telephone merit hearing from me, but the factors that I consider when I look at it is, first of all, they got to be legitimate. The fact that, well, it's more convenient to the parties to appear by Zoom, that's not going to cut it. And a lot of times if I see just one attorney, well, I'm out of town, I'm 100 miles away, but I look and I see that the rest of the parties are local, then chances are you're not going to get a Zoom at that point in time. It is going to be a live hearing. Evidentiary hearings, for the most part, they are scheduled live, a little bit more lenient on having those by Zoom, but logistically, it's problematic when I do the hybrids, because the way my hearing room is set up, that if people are sitting at the council tables and I'm at my desk or whatever you want to call it, it's what it is, it's a desk, the way that my Zoom camera is set up, we can't see it, and my computer screens are to the left of me. So even if I have it on two screens, you're going to see the side of my head, but I won't be able to see the Zoom screen if they're seeing it. So it's just kind of a problem. Now, most of the time, if it's a corporate rep that's out of the state or adjuster out of the state, something like that, or even a claimant out of the state, I'll make it work. But by and large, a simple answer is for merit hearings, all of them are scheduled live. File a motion otherwise. Evidentiary hearings, the same thing, but I'm a lot more lenient on evidentiary than opposed to merit hearings.
Thank you very much. Judge Johnsen?
Sure. The default for my final hearings are live, but as most of you know, we cover more counties than just West Palm Beach. We cover Okeechobee, Indian River, St. Lucie, Martin County. So in those instances, if the parties want to appear by Zoom, I'm more inclined to grant that, since I'm not going to make the claimant or the employer travel outside the county where they reside or doing business. For evidentiary hearings, I'll do either Zoom or telephonic, depending on what the parties want to do. I leave it up to them. Or if they want to come live, I'll never turn anybody away that wants to come live. Regular motion hearings, I'll do either by Zoom or by phone. But final hearings live is the default because I think it's important for the parties to be there. You have better command of the courtroom with the attorneys there, and also to judge the credibility and the demeanor of the witnesses that are going to testify live. Now, that being said, if there's a particular witness, as Judge Anthony indicated, that's out of state or located somewhere else, sure, I can do a hybrid and have that person testify by Zoom, or I can see them on a large screen TV, and the attorneys also have access to seeing that witness and questioning that witness, and that witness has the view of the entire courtroom, so they can see what's going on, they can see me, they can see the lawyers, they can hear everything, and I'm just now getting comfortable with the hybrid hearing, so I have done that in the past as well.
Judge Newman?
So in Tallahassee, we're a little bit unique because we not only have what were the traditional Tallahassee counties, but we've recently adopted about half of the Panama City counties and about half of the old Gainesville district counties. So we have sort of a two-factor approach in how we, by default, schedule our final hearings. If it's a Tallahassee case or a surrounding county case, the old Tallahassee district, those are scheduled by default live. The outlying counties from the old districts, some of those counties are over 2 hours away from Tallahassee. I'm not going to presume that you have a client, either whether it's an employer or a claimant, who wants to travel 2 hours away for a hearing. So those will by default be scheduled Zoom. A lot of times those attorneys are also out of town, so we'll default schedule those by Zoom. I have a caveat on all my notices of hearing that if you desire to have a live hearing in the county where the accident happened, so if it's Dixie County or Jackson County, Dixie County to our east or Jackson County to our west, for example, we can make arrangements to go to the county courthouse or some other facility that would take or accommodate a hearing. I've only had one group take me up on that, and I've been to the Madison County Courthouse, but that is a possibility. So I was just telling an attorney today, if you're in the old Panama City district and you've got employers and claimant who are in Panama City, we could potentially have a hearing at the old Panama City office or the local county courthouse who may already have security in place. So we can make accommodations if you do want a live hearing. Same for Tallahassee. If you've got Madison County is an old Tallahassee County, Tallahassee District County, we can go there. So if you've been scheduled for a live hearing but everyone's out of town, you can request a Zoom hearing. My only request is that it's made in a timely fashion. I recently had a Zoom request come in the day before. I like to have my IT staff on notice that I'm having a Zoom hearing, so if something goes wrong, I know who to call and when, and so it's just a courtesy. Give me some notice, and I'm more likely to give you what you want. If there, and honestly, on any given case, about half of the attorneys are out of town. I've got Orlando attorneys, West Palm attorneys, Jacksonville attorneys, so I'm reluctant for what might end up being an hour-long hearing, reluctant to make you drive up 4 hours from Orlando. So I'm pretty lenient in that regard, but again, make sure you give me appropriate notice, whether it's you want to go from Zoom to live or live to Zoom, just let us know so we can make those arrangements. Motion hearings usually are scheduled based on where the attorneys are. Again, if we're going to have a 30-minute motion hearing, likely a phone hearing is going to be fine for that. Evidentiary hearings I usually schedule by Zoom if the attorneys are out of town or the parties are out of town, because if that's going to require some evidence or witnesses, I'd rather that, at least me being able to see you on the video screen. So,
Judge Medina-Shore?
Yeah. So we cover Miami-Dade County and Monroe County. We now Miami are scheduling the final hearings and attorney fee hearings live, no matter where the attorneys are from. If you have a good excuse and you want to share that with us on a motion for Zoom, of course, we will read it. We will determine whether, we will allow the parties to go via Zoom. Monroe County, if you're in Key West, it's a 4-hour drive. So a lot of the attorneys or a lot of the witnesses are in Key West, we may, and we have granted Zoom appearance. What we do ask, and we put in our orders and our notice in order, is that if you're going to appear by Zoom, please make sure that the witnesses that you're going to call have a stable internet connection and Zoom capability. What I've found is that a lot of witnesses and that claimants, employer reps, that's across the board, want to appear by the phone in their car, and they're very distracted. We found many things. I've seen many things, and that I want to unsee via Zoom, in a phone, in a car. I don't want to talk about it, but so because of that, we really prefer live. We prefer in person, and but of course, you could always file a motion, and we'll read it.
Continuances, final hearings beyond 210 days, are permitted statutorily when there are circumstances beyond the party's control. Can you discuss, we'll start with you, Judge Medina-Shore, what generally constitutes and what doesn't constitute such circumstances?
Well, not starting your discovery in time is not an excuse. Not being prepared is not an excuse. Having schedule a doctor's deposition in plenty of time and having that doctor back out and not getting a date is an excuse. Not having a date, that's acceptable. The first question out of my mouth is going to be, what did you do to help with this circumstance? What actions did you take? And if I deem that you've done everything you can, and you've taken that action, and the continuance is appropriate, I will grant the continuance. If not, most of the cases are not. They're not appropriate, and I will deny it.
Does anyone else have anything else they'd like to address on that issue?
Yeah, I can jump in.
Sure.
Judge Hedler. Just to echo what Judge Medina-Shore said, if you wait to the last minute to get your IME because you're waiting to see if the other side gets an IME, that's not circumstances beyond your control. I don't understand why some lawyers wait or to see what the other side is going to do and then react to it. If you have a strategy for your case, go get your IME, get the deposition scheduled, and get it scheduled before the final hearing. Now, if the doctor cancels on you at the last minute, okay, that's circumstances beyond your control. The doctor gets called to surgery, you have to reschedule the depo, you can't get the date in before the final hearing. That I would consider circumstances beyond your control. But if you wait to the 11th hour because you're waiting to see if the claimant's attorney is going to get an IME, and now I need to get an IME, that's not circumstances beyond your control.
I'll add one more thing, that I have never granted a continuance without having a hearing on the motion to continue, except I recall one time where I think one of the attorney's spouses was in the hospital having surgery or something like that. But I do not, look at it and decide whether I'm going to give it, because I'm always going to be asking the questions, well, when was the deposition set, things like that. So you will always have to have a hearing on a motion to continue. So if you're filing one in front of me, your motion to continue, you might as well just call and talk to my staff and get it set for hearing, because I just don't, I give out a lot of them, but I freely don't give them out, I should say.
I have 2 points I'll raise. Number one is the way we do it in Tallahassee, and I think Judge Johnsen said he was similar, is we don't schedule pretrial and final until after mediation has been held, which is a little bit different than a lot of the judges around the state. Which I like it that way. I'm sure Judge Johnsen likes it that way. It keeps everybody's calendar clear up until you absolutely need the pretrial and final. You don't have a lot of stuff on your calendar. But anyway. That being said, I worry that this gives sort of a false sense of security in the attorneys' minds that, well, we can wait till mediation and see if it doesn't settle, then we'll get our discovery going. And I just want to try and disabuse you of that notion, because you really should be getting your discovery in before then. Because if you wait till after mediation with a lot of these doctors, you're not going to get those depots set within the 210. So that's just my little PSA. But the second point I was going to raise, which, I may have forgotten it, is, yes, I remember now. You know, I think we have to make a finding based on your motion that there was some circumstance beyond your control that would then allow you to, us to comply with the statute and give you the continuance beyond the 210 days. When you file your motion, you've got to give me something. Don't say, we've gotten together and we think we need more time. I'm like, no. There's a deposition that we've been trying to schedule. It didn't work out, Generally, if the other side agrees, I'll be in agreement too. Now, I'm not going to just leave it open-ended. I'm going to say, okay, I'll give you a month. I'll give you too much, how much time you need. But, the 2 months is kind of where I'll put the limit at. But don't say, we've really decided to privately mediate. Because to me, that's not something that was beyond your control. If you really want to settle, you can probably call up the other side and get it done. So just give us something that was the circumstance so that we can make that finding and feel like we can give you a legitimate continuance.
I'll just chime in real quick. Also remind that orders continuing final hearings must include the new date and time. And so when you file your motion, please be ready to talk about what kind of time frame you're looking at. Kind of going back to what Judge Newman said, like if you're way out and you're looking at 3 months and because your whole case is wrecked, that's going to be a hard sell.
Yeah,
So keep that in mind. That's a requirement. We have to have that in our orders. So you guys need to be ready to address it.
Tell us the date that the doctor's deposition is scheduled for in your motion. If you have to schedule it after the final hearing because of a cancellation, that will help us determine whether a continuance is warranted and how much of a continuance to grant.
Let's go back to Judge Newman. Can you talk to us about the distinctions and what you see regularly and what you'd like to address with the bar between motions to dismiss and a motion for summary final order?
Well, I do see a lot of motions to dismiss. And although they may contain some great arguments as to why the petition for benefits that's been filed doesn't have legs, it's not going to go anywhere, this has been resolved, there are very few reasons why I can actually dismiss the petition. The statute gives me the first reason, which is a lack of specificity. So if there's medical records not attached and you're asking for making a medical request and the crux of the medical recommendation isn't attached, that's a good reason to dismiss a petition if it otherwise isn't specific. But there aren't a lot of other reasons why I can dismiss a petition because the standard is I'm looking at the four corners of the petition, just like a complaint in circuit court. I'm looking at the four corners of the petition and accepting what they've put in there is true. So you may have lots of great reasons in your motion to dismiss. We've provided that benefit. This benefit's not right doing and owing. They're not at MMI. There's other doctors. I can't listen to that. I just have to look at the four corners of the petition and accept that is true. So most of the motions to dismiss that get filed, I have to deny because it's just not within my authority to dismiss the petition for that reason. But a lot of times, the arguments you're making are probably better left for a motion for summary final order. We've provided that benefit. Here's my adjuster's affidavit saying we've provided that benefit. It's not due. That may be a good basis for a motion for summary final order. But if you're thinking this petition isn't right, we shouldn't have to pre-try it and go to mediation. Think about what the reasons are for you wanting to get that dismissed, and then maybe a motion for summary final order is more appropriate.
Can I just add something too, that if when you're drafting the motion, whatever the motion to dismiss is, it's helpful, and you will know whether it's an appropriate subject matter for a motion to dismiss if you cite the statute section that you're relying on, right? So if you can't find the statute section that you're relying on, perhaps it should not be in a motion to dismiss. It should be in a motion for summary final order, right? I can't tell you how many motions we get with great explanations. It's probably a great defense, either in a motion to summary final order or in a trial, but not in a motion to dismiss. So keep in mind when you draft those motions to dismiss, that judge wants legal authority. don't ask us to do things that we have no legal authority to do, because that's the order you're going to get. You're going to get an order saying, we don't have the legal authority to grant that. Thank you very much. It's denied.
Let's stick with you, Judge Medina-Shore, and move on to pretrial stipulations. Mr. Ambikar.
He's got a question.
Motion to dismiss, something that I haven't seen a lot lately, historically, like it's always lately, is claim amending petition, but just filing another petition for benefits. It's basically the same as the first one, but with one change they want, like TBD starts 2 days early or something like that. It's an amended petition, it's not called an amended petition. I can't file a motion for summary final order because dismissing one of the two is not dispositive, the other claim is still pending. So I would call that a motion to dismiss. But you have to look outside the four corners because you have to look at the other petitions to see if there's another better petition out there.
So again, you have to go back and look at what statutory authority do I have to dismiss. First of all, it's not an amended petition for benefits unless the parties agree, number one, pursuant to the 60Q rules, or I order that it is an amended petition for benefits. So you can put whatever you want there. You can put amended, supplemental, fantastic petition for benefits. I'm going to treat it as a petition for benefits. That's what I'm going to treat it as, okay? And you be careful when you file these amended petitions, because if it's the same one, remember, if you need to voluntarily dismiss, there's that the double dismissal voluntary rule. So be careful with that, please. We're treating it as a petition for benefits. Again, if you go back and you put in your mind, I want to dismiss this, what is the statutory authority that I can tell this judge that she can dismiss it? If you can't give me one, then there's a problem.
I'm looking forward to the time I get to adjudicate claims from a fantastic petition for benefits. Very exciting. Pretrial stipulations. We talk about pretrials. I feel like at every seminar, we say the same thing. At every seminar, it is one of the most important documents, if not the most important document, when you are litigating a claim. And yet, persistent problems, persistent deficiencies. Judge Medina-Shore, do you want to talk to the bar about, we heard the lawyers talking at prior panels about these boilerplate affirmative defenses and avoidances in pretrial stipulations. Do you want to talk to them about how they need to draft affirmative defenses and avoidances in light of the 60Q rules requiring specificity?
Yes, I made notes on your panels, by the way, today, so
I was there. It's true. She was taking notes.
I'm taking notes. No, don't do it. Don't do boilerplate affirmative defenses, avoidances. It just shows me you're not prepared. You don't know what your case is. I get attached to the pretrial 2 pages, 3 pages of affirmative defenses, avoidances that don't apply. The vast majority don't apply. And when I sit down and I go through in the final hearing, I don't have the time to go through every pretrial that's filed. I just don't. We don't have the time to do that. I think the attorneys are very professional, educated, and can fill out a pretrial stipulation. So at the time of final hearing, when I go through all the claims and defenses, affirmative defenses and avoidances, boy, it's no, Judge, that doesn't apply. You can go ahead and strike through that. Okay, all right, well, what's the next one? 120 day, what does that mean? 120 day, well, I know there's a 120 day provision in the rule, but the 60Q rule, 6.1132H says that you have to identify and specify the detailing conduct that goes with it, right? You can't just say 120 day, estoppel, waiver. I get that all the time.
Estoppel of what?
Yeah, you don't know.
What are you waiving?
Yeah, waiver. And it's like, and they say it with such, and I'm like really, oh, wow, I'm like really impressed, but I don't know what you're talking about. So can you explain that? So, if a motion is timely filed, I'll strike it, and I'll give the 10 days to the time period, I think it's 10 days, to go ahead and file with specificity, right? So that the other parties put on notice, and then the discovery can be done. But that boilerplate, and it's across it's across the board, by the way. Claimant and defense, both of you are doing it. Both of you are doing it. Why? Why are you doing this? I don't know. But I surmise that perhaps you're worried, right, about that other provision, about amending pretrial stipulations, that you can't amend claims and defenses, right? That you should have brought earlier, right? And you're worried that if you don't put the kitchen sink in there, that you're gonna be waiving those, right? Right? Which means, to me, that you gotta get on that pretrial, you gotta get on that before the statute, before the 60Q rules say it's 2 weeks, and then you give the other side, a week, whatever it is, which you never do. You gave each other 2 days, maybe. But anyways, you need to go before that and get ready for that pretrial. Because what's the first thing I take out in any final hearing? If you've been in front of me in final hearings, the first thing I take out is the pretrial stipulation. That's the first thing I take out. That's the first thing if I'm going to print something, which I don't do anymore because we're fully electronic. But if I were to print something, it would be the pretrial stipulation.
Judge Medina-Shore, before we move on, can you just repeat for us one more time that tone you hear in your head when you read the word waiver? What was it again?
Waiver.
Okay, great. Fair enough.
That, I can't compete with that. That's well done.
Well, you're next, Judge Johnsen.
That's
Talk
fine.
to us about amending the pretrial stipulation.
can I
Judge
go-
Medina-Shore referenced it. Yes, you can circle back, but carry this on to the next
Yeah, I'm
thought.
gonna segue into this. As far as specificity, if I don't know what the hell you're talking about in your avoidance or affirmative defense, it's not specific. That's my simple test. If this just says waiver or estoppel, I don't know what waiver, estoppel, or what. Anyway, amending the pretrial stipulation. There's a rule right on point, and unfortunately, very few attorneys actually follow it. Mr. Bohr, I know you're smiling because you're one of the attorneys that does follow it, and you know what I'm talking about. It's 60Q 6.113 subsection 6. There's a whole paragraph that talks about amending the pretrial. If you have new claims or new defenses, what do? Well, the rule's very clear. You have to file a motion. I have to make a ruling that good cause exists for you to make that amendment. And part of the analysis is, as Judge Medina-Shore mentioned, could have been raised when you initially filed the pretrial. Is this something you just forgot to put in, or is this something that's come up new in the case? And the failure to diligently do discovery standing alone does not constitute good cause. So I have to make a finding of good cause. But invariably, what I see is attorneys just filing employer carrier's amendment to pretrial stipulation, affirmative defense, misconduct. Oh, that's going to go over real well. So file a motion. It's a new defense. Tell me, well, Judge, at the time we did the pretrial, we didn't take the claimant's deposition yet, and we took the claimant's deposition afterwards. Okay, well, the other side could argue, well, that they should have taken the deposition earlier, but at least I have a hearing and I have to make a finding of good cause to either allow or disallow that amendment. Witnesses and exhibits more than 30 days before final hearing does not require a motion. You can amend your witness list. You can amend your exhibit list. You don't need to file a motion with me. But if it's within 30 days of the final hearing, then you need to file a motion, unless it's stipulated to by the parties. The parties agree, we want that EMA doctor to testify, so we're going to file an amendment to the pretrial, and we're going to list the EMA doctor as a witness. Okay, you're all in agreement. But if you're not in agreement, you have to file a motion, and I have to approve it. Now, with all that being said, your pretrial stipulation controls. If you have a blanket pretrial stipulation that allows you to amend, you have an agreement in the pretrial. We can amend the pretrial whenever we want, anytime, any day, anywhere, up to final hearing. Well, that stipulation is going to control, because that's the case of Howard, ironically, versus City of Tallahassee. I don't know. It just happens I'm in Tallahassee, and that case is relevant to what I'm talking about. But in that case, the parties had a blanket stipulation that allowed them, anytime more than 30 days before the final hearing, they could raise new claims and defenses. So the claimant's attorney in that case raised an avoidance of 120-day waiver. The judge disallowed it, and the judge was reversed because the parties had entered that stipulation in the pretrial that allowed them to amend and defenses more than 30 days before final hearing, and the judge should have considered that avoidance. So if you're going to enter into a pretrial stipulation with broad language allowing you to amend the pretrial whenever you want, or within a certain time period, that stipulation you made in the pretrial is going to override the rule, and that's going to control.
Thank you very much. Let's talk about attorney's fees.
Time to go.
Attorney's fees. Let's avoid Miles for a moment, maybe fully. Let's talk about stipulations. Stipulations for fees, as I've heard the argument, should essentially require us to make sure that the I's are dotted and the T's are crossed, and then approve them without any scrutiny. I think everyone in the room probably is aware of a 70-page single-space order that arose out of the West. And so there are a lot of discussions
The
with
Wild West.
respect to fee stipulations. Judge Anthony, you're in the West. Are there any issues within fee stipulations which invite your scrutiny? If so, what are some of those issues, and how do you handle them?
Answer to the first question is yes, there are some issues. And I mean, I look at every single stipulation that comes in there on attorney's fees. And, you know, I think talking about a 70-page order, you know, the question that you got to ask yourself is, I mean, is there actually fee exposure? Was something secured? And that's what's troubling for me if I look at something and I see that, well, you're paying this fee, but what is the fee for? For example, I had one that they go to mediation, the case is a total controvert, and then the case settles for a lump sum, and then there's an agreement to go ahead and pay an additional side fee. And I'm not sure what that's for, when the settlement is for all past, present, and future indemnity and medical benefits. So those make me scratch my head saying, I don't understand. You still have to show that you secured a benefit. I mean, you just can't say, oh, well, we've agreed that I should get another, you know, $5,000 because you know, you know who I am. I get it. You
It's a
know, I get
ransom. It's a ransom.
Exactly, exactly. And, you know, one of the things that I've heard about that order that has been uploaded and floating around out there is, you know, the EC, listen, the EC wants to go in there and they're like, okay, we'd like to settle this case. And we have this amount of money to settle this case. And everybody wants to get this case settled. You get into a problem and you say, well, you go ahead and split it up, or there's not a discussion about that. There's got to be a clear, discernible discussion about what that side fee is for versus just here's money for this, take and do with it what you will. So I look at that. The other thing is when I get these stipulations, I get a lot of times the stipulations, we the you know, EC agreed to pay the claimant's counsel $5,000 for all work done to date. What is that? I mean, there's got to be like a petition filed. Give me the name of or give me the date of the petition. Tell me what benefits you secured. Don't say any and all. And I've asked somebody, you know, why is it that y'all write those stipulations? And I've been told, well, the employer carrier doesn't really care so much because we just want to get rid of all fee exposure. So we leave it on the claimant's counsel to put in an affidavit what it's due. I can't tell you how many times that even as vague and as short as it is, it doesn't match what's being said in the attorney fee affidavit. And that creates a problem. Your stipulation should say what the fee is, what it's based on, and why you're entitled to it at the very beginning. That's every step, regardless of what's in that attorney fee affidavit. And then, with the attorney fee affidavit, what I make sure is that that's the same as the attorney fee data sheet, which a lot of times it's not. And none of it seems to be like a picture. You should be able to pick up individually each one and see what it's for. Not, well, I'm going to add A plus B plus C plus D, and then I get my solution to the problem. So I do agree that, you know, I'm not supposed to go behind the stipulation itself. I think, you know, there's case law there to that effect, but it's got to be a legitimate fee in the first place, and you got to tell me what it's for.
Judge Johnson?
Yeah, to echo what Judge Anthony said, it's got to be a colorable entitlement to fee or a reasonable argument that there's a fee entitlement. I look at these, I'm not going to sign an order approving something that is not legally correct. So although we don't go behind the stipulation, you have to at least give us some reasonable explanation for the fee entitlement. It's especially helpful if you cite to a petition for benefits that was filed and say, this is the petition, the date, this is the benefit that I obtained, and this is the amount of the fee. I know, Judge Hedler, I've talked to you about this. I received a settlement package from one particular case where there was a settlement plus a side fee. The only problem was the case was settled within 30 days of the petition for benefits. So I set that for a hearing, and the attorney gets on there and says, you know, I was watching the hockey game last night, Judge, and I finally figured out why you set this for hearing. So we settled the case within 30 days of the petition. I said, there's no legal or argument or reasonable argument that you could have entitlement to a fee when they're paying the settlement within 30 days of you filing the petition. So that's just an example of things that I look for when I'm reviewing a stipulation, to make sure there's some colorable argument that there is fee entitlement.
Judge Newman, is that an issue you deal with?
A little bit. I would say more from out-of-town attorneys than in-town attorneys.
From Orlando,
Yeah.
Tampa area.
We'll get to you next, Judge Medina-Shore. You're not going to be passed over.
You know, I've
Neighbor.
heard some claims attorneys say, I don't go into a mediation and try and resolve any prior fee claim I have alongside my claimant settlement, because it puts those two things potentially at odds. And if you've done that and it has the appearance of, well, this was just a settlement and you're trying to get more of a fee maybe than the statutory fee gives you, or maybe than a miles fee would give you, you know, that's when it's going to come under scrutiny. Well, is there a basis for some higher fee than what would otherwise be a stat fee or maybe a standard miles fee? You know, so on those, I may call a hearing to say, you know, and sometimes it's just a matter of documentation. The documentation that's submitted with the original filing isn't adequate. So I may call a hearing on those. And so it may just be a matter of, oh, sorry, we didn't explain that well enough. Here's my fee entitlement. So, you know, you can help yourself by, as has already been said, make your stipulations or your affidavits very specific and you know, provide a payout ledger showing that this benefit was paid. That may help yourself to avoid having to come in and have a hearing on the issue.
Judge Medina-Shore, how do you look at fee stipulations?
I try not to. Fortunately, it's part of my job, so I have to look at them. No, I echo all the comments here. I'm trying, it's a stipulation. Stipulation means agreement. So there has to be some sort of language in there, in the stipulation itself, that, as to entitlement. And, you know, it's what raises red flags. You know, we get a lot in Miami. So what could raise a red flag? Well, you know what, I look at the docket. I'm sorry, I look at the docket, I look at everything you give me. I look at the docket because there's case law that says I can look at the docket, and it was Judge Newman's case, that we can, and washouts and stuff like that, we can look at the docket. And, yeah, I don't remember the name, but it was yours. But, you know, if there's 3 documents on the docket and there's no PFB, or, you know, if I can't make heads or tails and you're not giving me the information, then it might raise a red flag. I've had cases, though, where there's nothing on the docket, but the attorney explains to me, I was retained like 2 years ago, and this is everything that we've done, and the parties stipulate, and on this date, we realized that we didn't, calculate the average weekly wage correctly. The claimant was paid back due benefits. I mean, but you wouldn't know it unless, looking at the docket, because the case has been going along without the necessity of our, intervention, the judge's intervention. So, we're primarily going by the documents you give us. So if you're not convincing us on the documents, then you need to go back and see what kind of language you can do to convince us. That's all.
Yes, sir.
With regard to a washout settlement and a miles fee, if the retainer agreement is filed, legitimate waiver, do you all require the claimant lawyer to also break it down to determine what the hourly fee would be based upon their hours, or is it sufficient that the claimant sign a fee agreement for 25%?
Are you asking, do we require an affidavit
They need to have an
that
affidavit.
go through the factors?
An affidavit or,
Right.
well, a Lee Engineering
Yes.
affidavit
Absolutely.
to include hours.
That's one of the factors, yes. But it would be all the Lee engineering factors have to be addressed because it exceeds a statutory fee.
So anytime that there's a Smiles fee, you're going to have to go ahead. And, I mean, you got to do the Lee engineering factors regardless of that. And again, it's not, I mean, I think I guess we're going to get into it. I mean, it's not necessarily that,
I don't have to let him hijack this. I mean, no, just kidding.
yes, we do.
Who is that masked man over there?
Ms.
Occasionally,
Hazeltine.
we do get an affidavit where it just talks about waiver and the contract and doesn't include the hours. And to me, that sort of, most of the affidavits we get go through the Lee engineering factors, and that's one of the factors, so the hours are included. So to me, it's a little bit like, why didn't you add the hours in? Is that now something I should look at? So I will usually say, why don't you amend your affidavit? And that doesn't mean you're not going to get the fee you've requested. It just means that's a factor, and I would like to look at it.
All right, hang on a second. Ms. Hazeltine.
Can I just ask for a little bit of guidance from you guys from a claimant's attorney's perspective, as far as how you guys would prefer to receive our time evaluations? Because for us, it's difficult without having any hard and fast guidelines of what's supposed to be in your timesheets, and can I include my paralegal's time, or is it strictly attorney time? Or, I mean, how far in depth do you guys prefer that we go into all of that when we're providing you with our affidavits and our breakdown? Because even some of like the billing software doesn't have the capability of separating out attorney time from paralegal time. And with that even being said, as well, I'm sure a lot of other claims attorneys would agree with me when I say that, my attorney's fee also goes to covering, the overhead of the firm and the work that my paralegals are doing. And then when I'm billing for, the review of their work, I've been scrutinized because it's like, oh, well, that's clerical or administrative, when realistically, it's not, because it's my name at the bottom of the document that's being reviewed and being sent out, and that kind of thing.
Okay. If you
Well,
can
let-
address
let-
it
yeah.
without an advisory opinion.
Yeah, there's case law that gives a very good overview of what to include in your time. I, for one, whether it's miles or EC paid fee, I use, we go through the Lee engineering factors. You tell me what your time is, your hours, unless there's something like really glaring, I don't want your time. I really don't, it's not enjoyable to look through, the timesheets.
You don't want time sheets.
No time,
You
yeah,
want the
no,
time,
I
you
just
don't
want
want
the
the
time
time
because
sheet.
of factor, the engineering factors. But if I were to, because there were cases that I have asked for time, according to the case law, you are supposed to be very specific in your time, keep your time. You are supposed to put which attorney is doing what, and which paralegal is doing what, and you're supposed to give a brief description of what that was and how long it took. Just like defense has to keep their time. And you have to keep it contemporaneous. That's what the case law says. For me, I ask for the timesheet rarely. I mean, it's rare. It has to be something that it doesn't make sense to me. Like if you're giving me 1,000 hours and there's 3 docket entries and that's it, and there's no more. There's just no more.
In 1 month.
In 1 month. it just doesn't make sense to me, so you need to like explain to me, and I'm not getting it from your affidavit, right?
That's a key point, though, isn't it? I
Yeah.
mean, if your affidavit is thorough and comprehensive with respect to the factors and explaining why the fee is reasonable, the timesheets are oftentimes unnecessary.
Correct.
Now, I know some judges require them as a matter of course, and that's a different issue. That's how they want to run what they require, but that's different. But the point that I think Judge Medina-Shore, and I would definitely echo it, is the affidavit is the starting point in terms of assessing that. And if the affidavit tells the story and explains it, great, you've done a great job, and you probably will have less scrutiny on your fee. Judge Anthony, I know you wanted to jump in.
Well, I would also point out that, yes, you do need an affidavit of the specifics on it and on timesheets. I generally don't ask for timesheets unless, like it's been discussed, if you're saying that you've settled this case for, I don't know, $100,000, you had the case for a month, and because, and you're getting a $30,000 fee, I'm going to scratch my head and say, well, I don't understand what you could have done and the amount of hours that you put in there. And then you get these things, and sometimes we get these timesheets, and I'm looking at it, and it's like 2.5 hours to put timesheet together. How is that contemporaneous with keeping a timesheet in the first place? And then we say, well, yes, the hours are only a factor to look at, but when you are saying that my paralegal has done 40 hours, I've done 10 hours, and it just so happens that it works out that I should be getting $550 an hour. Again, it's only one factor, I'll give you that. Complexity of the issue is what I look at a lot. But when you're saying that I should be entitled to $550 an hour, well, you're asking me to go ahead and give your staff also $550 an hour. And I understand your argument that, well, we have to pay for our staff and our overhead and their salaries and things like that. If you are paying your staff $550 an hour, you shouldn't have a business. I mean, no offense. I mean, my assistants throughout the years, they probably knew more than I did. But you have to look at a perspective, be specific, use common sense, and realize that if there is a question, or you can look at this thing and say, well, I got 72 hours in, I've had it for 30 days. That is a red flag. You are going to have to submit your sheet.
Why should you be penalized for quickly and efficiently doing your job? If I can get a
Wait, I'm sorry. 72 hours in the first month is efficient?
Well, what I'm saying is if I quickly settle a case, like I get a case and then very quickly settle it.
Okay, but the point he was making is there's 72 hours. So that's a different, you're asking a different question of whether you settle the case in a month and you only had an hour and a half. Should you get, right? Should you be penalized on the high hourly rate now? And that's a different factor. But I would point out, everyone seems to kind of lose steam after factor A. And I don't know why that is. There are a lot of factors. You all don't want us wholly relying upon the resulting hourly rate. And yet, oftentimes, you put all of your energy in factor A, which talks about the resulting hourly rate. So why do I not see the other factors really addressed? I'll give you a very, very common deficiency in the factors. One of the factors is the value of the benefits obtained. I've lost count of how many times that factor simply states the value of the settlement only. Even though you've represented your client for 2 years and you filed 13 petitions and you've arguably gotten a lot of benefits, I don't hear anything about that in the factor. Why not? You all need to look at all of the factors, especially when you're arguing. We need to look at all the factors, and it would help things a lot. So when you get into questions like, hey, I settled the case very quickly, there are other factors in there that you could potentially show off the value of that fee and why it's reasonable instead of just sub A, because we're fine not relying only on factor A. If you guys will give us some substance on the other factors, that's just pet peeve.
And
Anyway,
let me just add this, I'm sorry.
Okay.
And factor A is novelty, difficulty, and includes the hours, right? Which is what we're talking about. So I don't know what happened, and then maybe in FWA or another or in the Florida section or something. There's this affidavit, this form affidavit that has this huge, like several pages in factor A with case law and explaining to us why, a percentage is okay and all this stuff. Of course, you give us the hours because it's part of factor A, but, very rarely do I get explained to me the novelty or difficulty or anything about the case. So I get this whole thing about the First District Court of Appeals and Miles and Castellanos and all this stuff that all you came up with at one point in time and you've shared with one another. Then you say, and this is what you're supposed to do, and then you give me your hours, and then I'm left with, all right, well, what happened here? Was it a difficult case, or was it a difficult client? Was it a complex issue? Let me know a little bit about your complex issue. And that is also very routine. And when I schedule a status conference and I ask them, the attorney then says, oh yeah, let me tell you about this case and how complex it was. And I said, well, that would have been nice if you would have included it in the factor. So you need to put like 1 or 2 paragraphs in reference to explaining the case in that factor, not just the history, the case history on fees, and then the hours.
If you're
All right, hang
using,
on one second.
if you're using
Hang on
a
one second, I'm sorry. You have excuse to leave early if you so wish.
Yeah, I
It's
have to,
fortunate. Thank you
get
very
a
much,
flight.
Judge Medina-Shore.
But so sorry, Stuart. I'm so sorry.
Hold on. We'll run it. We'll run your questions. I want to let her go, okay? Thank you, Judge Medina-Shore. You wanted to address something real quick?
Yeah, if you're using a form affidavit where it's just fill in the blank, and, I mean, when it's so blatant that there is a line on it, and there's just a 5 hours on it, then the explanation is, I conducted discovery. I made phone calls. I wrote letters. Therefore, I'm entitled to it. That's not going to be sufficient. That will be a red flag saying, well, you didn't say anything, or fill in a blank. See payout sheet. Well, first of all, there's never a payout sheet with settlement documents, but it's written in there, see payout sheet, 5 hours blank. I mean, come on, most of the time, the affidavits are perfectly fine. Y'all do a great job with that, for the most part, but there are the ones that are fill in the blanks, and those just are not going to be accepted.
All right, I want to be very respectful of everyone's time. You have a quick question?
Yeah, if Andy Bora is on the other side, can I get a premium?
It's one of the factors, is it not? Okay,
That's
so
a
why don't we do this?
multiplier.
Again, I want to be very respectful. Thank you all very, very much for your attention today. We've had a great pleasure. It's been our honor. Thank you to all the speakers. Thank you to WCI, the First DCA, and JOA.